A very warm welcome. Good morning, all the fellow distinguished legal practitioners, students, and law aspirants joining us from different regions of Maharashtra. As we commence with today's Sunday Law Bulletin session, let me give a brief introduction about LDF to all the newcomers. Lawyers Development Forum promotes interest in the legal field by organizing such academic lecture series and sports activities for advocates. These include cricket matches and badminton tournaments as well. Our forum also hosts conferences featuring esteemed judges and expert speakers providing valuable guidance and insights. Additionally, we host the Weekly Sunday Law Bulletin, as you all know, where experts from various legal specializations share their knowledge and address key topics of importance. And today also we have an eminent and a distinguished speaker with us. Before we go ahead with their introduction, let us take a minute to be grateful to Advocate Dr. Rajendra Anbhule sir, Founder President LDF, Advocate Vijay Shelar sir, Secretary LDF, Advocate Abhishek Jagtap sir, President LDF, for starting with this endeavor. As we move ahead briefly, let us walk through our program schedule. We will have the first today's session from our distinguished speaker, followed by the question and answer round. Before we venture ahead with the introduction, a small insight into the Q&A. I would really welcome, or rather we would welcome question and answers in the written format. Once these written format question and answers are done, then we would move ahead with the oral question and answer series. And those would be at the end of the session. Now, as you all know, today we have with us Senior Advocate R.B. Jagtap sir, a name synonymous with deep legal insight, courtroom experience, and academic excellence. It is truly an honor to welcome you, sir, as our esteemed guest speaker for today. And he's one of the Pune's most respected names in the field of law. Senior Advocate Jagtap sir has been in continuous practice since 1978 and bringing with him more than 45 years of rich and diverse legal experience, almost 4.5 decades. A gold medalist and a university topper in LLM from the University of Pune, he has consistently been ranked among the top performers throughout his legal education at ILS Law College. Over the decades, Sir has built an illustrious career, handling vast range of matters before the High Court of Bombay, Supreme Court of India, and multiple tribunals. His exceptional command over service jurisprudence and administrative law has made him a trusted counsel before both Maharashtra Administrative Tribunal as well as Central Administrative Tribunal. He has represented prominent organizations such as Bharat Forge, Kalyani Steels, Kalyani Seamless Tubes, Indian Seamless Steels and Alloys, Steel Authority of India, and many others, earning widespread recognition for his strategic advocacy and clarity in complex service and industrial disputes. Additionally, Sir has also appeared in civil, property, and arbitration matters. He has handled high court writs and participated in arbitrations involving both national and international parties. His balanced blend of academic depth and courtroom precision continues to inspire both the practicing and aspiring members of the bar. Today, we are privileged and honored to have him guide us through a very vital and a very important, insightful topic, that is documentary evidence in civil cases, where his insights will bridge the gap between procedural and understanding the effective courtroom practice. On behalf of the organizers and all our attendees, we extend a heartfelt welcome to you, sir, and we look forward to your insightful session. Sir, I'm now muting myself and turning off the video. You may now kindly proceed with your session, sir.
Hello,
Yes, sir, you're audible, sir.
welcome all. I must appreciate the efforts of this organization to educate juniors, seniors, mid seniors, and all the legal fraternity or the persons who are interested in law to know or to learn about the various facets in the legal profession. Now, today's topic, which is there, is about the documents proof in civil cases. Though it is restricted to the civil cases, the proof of the documents in all branches of law is required. I will start from the basic of the proof of the document. One is that the original documents or the best evidence is to be produced in the court. The production of the best evidence itself doesn't remove or doesn't lead to that the documents are proved or the case can be established on that basis. The further role is of advocate as well as the judge to exhibit or mark it as exhibit the said document which is in a original form. The why the original is required has gotten a long history, because the document itself is an evidence. No other evidence is required if the original is there to prove a particular transaction or agreement. Now, this is a very vital aspect for a civil lawyer to know whether the document needs to be exhibited and how it is to be executed. This may be a little theoretical in part, but practically it is very necessary for a lawyer to understand how to prove a document. Now, once the document is produced in the court, that itself doesn't get the document exhibited, and even if it is technically exhibited, that cannot be read in evidence or appreciated in the evidence. The document has to be proved. Now, what is the method or procedure for proving a document? The document can be proved by the person who has signed the document or authored a document. The document can be proved by the persons who have seen the person writing or typing the document and creating that document. Now, this process is essential. So, production of original document, then evidence of a person who has authored or signed or who has seen it signed, all is essential. Now, this takes me to the cases where there is a specific requirement of the law to prove a document, especially a will. In a testamentary succession, the will is required to be proved under the law as per the procedure prescribed under Evidence Act read with Indian Succession Act. Now, the will has to be proved by calling one of the attesting witnesses. There are two attesting witnesses, at least one attesting witness. It is a misconceived notion that you need a doctor or you need a notary before whom it is signed. You need an attesting witness who himself was present when the will was executed and he has seen the executor signing the will. These are the basic or preliminary requirements to prove the will. So a document like a will is a special document which requires a special proof or special kind of evidence to be laid before the court. Now, there are another instances where the documentary evidence can be laid and the other party who is in possession of the originals can be asked to admit the document. That is Order 8, Rule 5. The person who is in possession of the original document has to produce that document. If a plaintiff or the party to the suit does not have the original document in his custody or possession, such party can ask the adversary to produce the original before the court. Now, if the original is not produced, what are the consequences? And if the original is produced, what is the proof or what are the kind of evidence? What is the kind of evidence which is required? Now, if after a notice to produce the document is not produced, then in that case, the adverse inference can be drawn by the court, because under section 114 of the Evidence Act, there is a presumption that the original in custody of a person, if not produced, it is assumed or presumed that that document is against that person or contains such a facts or material which is against the interest of the person who is not producing that document. Now, we turn to the case law where the document is produced, but there is an embargo upon the court not to read the document or cannot read the document. And that is because there are other incidental provisions of the other enactments like Bombay Stamp Act. Now, under the Bombay Stamp Act, there is a provision that the document must be stamped. You may be knowing that under section 17, all the documents where the transaction or where the property, immovable property is transacted, having a value more than 100 rupees, has to be on a stamp paid on it and registered. So such a document, take an example, document is produced which is not registered. What is the fate of that document? Second, a document is produced which is registered, but a stamp is insufficiently paid or not properly paid. Or take an example where the agreement is there, which is not on a proper stamp paid on it. For example, in case of an agreements with the builder or agreements for development, the law has developed over the period of time, which requires the developer or the owner to pay the requisite stamp as per the Stamp Act to be considered it as a development agreement or agreement for transfer of rights to develop with a right to sale in the property. So this, if it is not properly stamped, that cannot be read by the court as per the Stamp Act in evidence, and the court is prohibited or prevented from considering that document. Now, this is especially in cases where the documents are prepared on a stamp of rupees 100 or 5 in olden days, and those documents are acted upon. But when a dispute comes and a party goes to the court, then in that case, such a document, if it is produced or sought to be relied upon, then in that case, the court cannot take into consideration of such a document. There is a provision where the court has to impound, that is, send it to the registrar of assurances for calculating the proper stamp and collecting the stamp duty along with the penalty. Now, this arises especially of late in arbitration matter. The construction contracts are entered into on a stamp of rupees 100. However, such agreements lead to a dispute between the parties if subsequently, then in that case, the arbitration is appointed as per arbitration clause. Because under section 11, the party can go to the High Court and get the arbitrator appointed if the adversary refuses or does not act as per the arbitration agreement to appoint an arbitrator. Now, before the High Court, the only issue is that whether there is an arbitration clause. And a High Court has settled. I will give the case law on this. There is a number of cases on this. High Court only decides that whether there is an arbitration clause, and if it is there, the High Court will appoint an arbitrator. And before arbitrator, the issue again will come whether the document, that is an agreement, because in Maharashtra, such agreements are required to be stamped at the rate of 2% of the contract value. Heretofore, the contractors or persons who are undertaking to the various projects, they did not bother or they did not require to address this issue. But when dispute comes, this issue becomes or attains a vital importance. Now, before arbitrator, once the issue is raised that document is not properly stamped, in that eventuality, arbitrator, being the nominee of a judicial stature or a judicial officer in a way, has to impound that document and get it stamped. And unless it is stamped, the further proceeding of the arbitration cannot be continued. So this is a very vital thing that the lawyers or the legal practitioners must know. Now, the another aspect is what happens if the original document is lost and the copy of the document is sought to be produced. The law in Karthik Bhatt's case is well settled about the production of or leading a secondary evidence. Once the original is not found to be in existence or not traceable, the copy of the original or mechanical process, if the copies are made, previously it was typewritten and carbon paper used to be inserted, or a cyclostyle papers used to be cyclostyled, or a Xerox copies, they all become a secondary evidence. The secondary evidence can be laid without requiring any application or a permission from the court or to the court that the secondary evidence may be allowed to be laid. This secondary evidence is also requires to be proved. The pre-existing condition for such secondary evidence is that existence of the original document has to be established. One cannot jump for a secondary evidence directly without establishing, showing that there was an original document which was in existence. And this secondary evidence or the documents ought to be produced is by mechanical process or by the process by which the document are typed. Now, such secondary evidence has another facet which I will deal it now. Now, this is very important, especially the legal fraternity, which is by and large expanding with a new entrance in this field. And they must know and they must be aware that new technologies and techniques have entered into this field. And this technology is of a computer or the digital evidence. A separate enactment is there in 2000, year 2000, that is called Information Technology Act. Now, this Information Technology Act is a very peculiar legislation where because of that and under that, there are amendments effected in the Evidence Act, Criminal Procedure, and also the other branches of the law where the digital evidence has attained the importance or vital importance. Now, this digital evidence, again, the question will be how it is to be proved and how it is to be established. Now, digital evidence is again a form of, as I told earlier, is a secondary evidence. It is not a primary evidence. It is not an original document or original evidence. Now, if it is a secondary evidence, as I stated, the existence of original or existence of the original recording or digital original computer recording has to be established. Now, this has brought in by amending the Evidence Act by introducing Section 65B. Now, Section 65B, I will first give an illustration by way of a case, and then I will come to the niceties of that law. There was an election in Kerala. In that election, the propaganda was made through pamphlets and videos about a murder sponsored or helped by the opponent candidate, and these leaflets and videos were distributed all over the constituency. The winning candidate was responsible for such information, digital information, to be circulated. That was the case. And this case led to the filing of an election petition. In an election petition, peculiar words are about corrupt practices. Now, these corrupt practices was sought to be established through the digital evidence. That is those CDs, videos, pamphlets which are printed in n number, the person who printed, this all became the part of a court record. Now, in this case, you can note down the case, that is Anwar PV versus PK Bashir, reported in AIR 2015, Supreme Court, page 180. Now, lower court admitted this evidence. The various songs in a digital form, various announcement, leaflets, CDs, videos. This matter ultimately went up to the Supreme Court for setting aside the election by the candidate who was second in number of voting and sought a prayer by prayer that he has adopted corrupt practices and therefore the winning candidate's election be set aside and he be declared as elected. Before the court, the question came as to what are the requirements or necessary ingredients to establish the facts which are sought to be proved or sought to be brought before the court through this digital type of evidence. As I stated, this is not a preliminary primary evidence. This is not the original evidence. So the burden is upon the person who seeks to produce this digital evidence before the court. And what are his responsibilities or what are his duties to establish this digital evidence? For that purpose, this case may be treated as a pioneering case, putting some controversy at rest. What was the controversy? I will deal with later. It requires that under section 65B subclause 2, the various parameters are prescribed. And I will just briefly state what are the parameters which are required to be stated and the parameters about admissibility of the electronic evidence. First is the computer containing information was produced by the computer during period over which the computer was regularly used to store or process the information for purposes of any activities regularly carried out over a period of time. Second, during the period, information of the kind contained in the electronic record or the kind from which the information so contained is derived was regularly fed into computer. That is, you feed an information to the computer regularly on a regular basis and the same computer in the ordinary course of said business, because now all commercial transactions are through electronic media. Now, third is throughout the material part of the period, the computer was operating properly. Even if for some period a computer was not operating, was closed or under repairs, then in that case, it was in such a condition that was not such as to affect the electronic record or accuracy of the contents. That is, a malware is not entered or that there is no tampering. During the period, it was not in operation. So, now information contained in the electronic form reproduces or derived from such information fed into computer in ordinary course of said activities. Now, there can be a case where there may be many computers operating. That is a branch office at Pune, head office at Bombay. The information is fed in Pune, which is transmitted to Bombay. Bombay, there is another transmission to Delhi. So all these computers which are linked, all these digital electronically linked, it requires that they are in the same chain. And the same conditions as I have narrated earlier have to be fulfilled. Now, all this, how is to be established before the court? That is another question. Now, this requires, that is what the PV Anwar has established or laid down a law, that a certificate is required, and that is called a certificate under 65B. Who gives the certificate? The person who is operating, in charge, controlling the computer or the computers if it is series. he can certify that the computer, make mentioning the name, make of the computer, the period during which the data was fed, period during which the data was retrieved in its original form or produced before the code. This all will be the part of the certificate. So certificate must contain identification of the electronic record containing statement and described the manner in which it is produced, and secondly giving particulars of the device involved. Now what is it? Is a Dell computer, it is a another computer. The name of the computer or the details of the computer or a device are very particularly essential, and he has to certify about the prerequisite conditions, that it was operated regularly, data was fed regularly, even if it was not in operation, that was at a such a stage that no data is harmed, tampered, or malfunctioning. So these all requisite requirements are to be stated in the certificate, which is called 65B certificate. And once this certificate is produced along with the electronic data, then and then only the court can look into such evidence, and that evidence can become the part of the evidence before the court to be relied upon or to be considered, appreciated by the court. Now we turn back to our case in PV Bashir, PV Anwar. What happened? In PV Anwar's case, the data was produced, CDs, etc. were produced. The persons who produced the exam were examined before the court. But the crucial question was whether they have produced a certificate as required by section 65B2. The answer given by the Supreme Court is in the negative. And as a result, though the evidence is there before the court cannot look into such evidence which is not supported by the requisite certificate, then the case has to fail. And accordingly, the conditions not complied under section 65B, and that election challenge failed. This is a case which sets some guidelines for the courts to consider the digital evidence. Now, there is one more case of on the same topic or subject, is of Arjun Khoth. Was again an election petition. The facts in this case were that the election process was completed at say 5 o'clock. It was a contention of a defeated candidate that even after the closure of the voting, between 5 p.m. to 6 p.m., there were votes cast at particular voting stations. How did he bring this challenge before the court? He brought the evidence through the election officer of the footage, CCTV footage, which was there in the election room or in the election commissioner's office. This was produced by the election officer at the behest of the court summons. However, also in this case, the authenticity of these videos could not be tested for lack of or want of the 65B certificate. These are very crucial points which the courts have underlined in the said case also. So in order to understand the leading of a digital evidence, one must consider the provisions of section 65B. Hitherto before, as I referred earlier, there are provisions about proof of by secondary evidence under section 62 to 65. A secondary evidence, say copies, normally the photos are produced, can be laid before the court by examining, say, a photographer who took the photos, who developed the photos, and that is sufficient. The question arises that if these provisions are sufficient to prove the secondary evidence, why the certificate is also necessary? Now, this was a theory which was relied by the Supreme Court in parliamentary case, that is Navjot Sidhu's case, and also subsequently in another case of which I will give the citation. These cases were on the basis that even though there is no certificate, we can rely on the evidence because secondary evidence can be proved under section 62 to 65. This particular view of the Supreme Court is set aside in Muhammad Afzal, that is Parliament case, and Navjot Sidhu. Those are the cases of 2003 and 2005. And in PV Anwar versus PK Bashir, these judgments are overruled and the law is restated as to the requisites for establishing or proving the electronic evidence before the court. And this is very vital and material because all of now in civil law as well as criminal law, maybe it is a document, maybe it is a video recording or audio recording. Previously, even before the coming into force of these provisions, there were audio recordings which were sought to be proved before the court. And there were another person or the persons involved in this process to prove such audio recording. And those were the experts, voice recognition. Now, these experts may be about voice, may be about the quality of the recording, are important persons to prove that particular kind of evidence. Basically, let the lawyers remember that law on the expert evidence is very clear. Expert evidence is always a weak evidence. It is an help or assistance to the court. So solely reliance cannot be placed on an expert, be it maybe for handwritings, maybe for signatures, or maybe for other purposes. These experts, as per Evidence Act itself, are read with the judgments over a period of time, are only having a value which is not a conclusive, but maybe a corroborative. And this corroborative value to such evidence has to be borne in mind. Because normally in case of will, this document comes into picture only after a death of a person. Now what happens and how the signature or the document's writing is to be proved. Now this is a very crucial job for a lawyer who wants to support the will. Always the challenge to the will is that will is not genuine, will is fraudulent, or will is obtained by practicing fraud. Now in these cases, experts' evidence as to handwriting of the testator or a thumb impression of the testator are crucial. Because sometimes the attesting witnesses may be a relatives, a person interested or having some remote interest in the benefits arising or accruing because of the will. So such experts are examined before the court by asking them to give a handwriting expert's report. Now they are actually, there is a handwriting expert, or we call it as in a criminal cases, forensic analyzer, head office at Nagpur. Now these handwriting experts are trained to understand the niceties of the handwriting, signatures, whether it is cursive writing, whether there is a gap, how the letter is written by the testator, particular letter, say P, is written in a particular form, and whether the similar form in on admitted document, whether the testator's admitted documents are scanned or perused and compared with the document like a will, which is a subsequently produced. So here the task of the lawyer and task of the judge is very difficult to appreciate, understand, and also draw a conclusion that this is a genuine document. So this is how a document called will is required to be proved before the court. So there are facets where sometimes the document is not in an original form. The document is in the copy. Now, whether a copy of a document can be proved and can be brought before the court, the answer is yes, because it will be a secondary evidence. But that copy, if it is there, as I stated earlier, must be shown that there was an original in existence. And this copy arises, say, maybe a typed copy of which the carbon copy is sought to be produced, or a copy of which is the Xerox is sought to be produced. Must be shown that who made the Xerox, where the Xerox is made, or which computer or typewriter it was typed. All this has to be brought before the court. So, in order to bring such kind of secondary evidence, the burden is heavy, more upon the person who seeks to establish that it is a copy of the original document. It is not possible for anybody to bring a document which is more than 30 years old. And in a civil law and civil cases, normally they drag on for years, or even the persons become aware of the document after some years when the dispute may be pending at various levels. So what is a provision in respect of a document which is very old? The law provides that a document which is more than 30 years is presumed to be or is a original document, is a correct document. So because of the passage of time, Evidence Act has provided that if it is a 30 years old or more, then document is presumed to be genuine and it can be exhibited. Now there is another facet to my narration. If a document is manipulated or is scored, overwritten, how the civil lawyer can establish that it is a forged document? It is easy to say, but difficult to prove. The forgery on the document will have to be proved by cogent and corroborative evidence. Because at some stage there is a overwriting or there is a particular word score, that doesn't lead to a conclusion that document is forged and cannot be relied upon. Here, the lawyer has to examine whether that particular term which is scored is a material, vital in the entire document. Number two, whether the scoring is visible by naked eyes. And if this manipulation or is a scoring or overwriting is visible with the naked eyes and it is in respect of a material part, then it is easy to lead an evidence that document was brought into existence by forgery, by overwriting, and that will disprove the document totally. But if it is not in respect of material part, if it is not of a vitally important admission on the part of the adversary, then in that case, the difficulty is this kind of document cannot be thrown away or neglected. Now, for that purpose, under Evidence Act, the provisions about the various provisions are made about the admissibility of the document, and those are from section 61 to 90. Those provisions are about the documentary evidence, because I have dealt with the documentary evidence, secondary evidence, and also the electronic evidence. They come under this particular chapter 5 of the Evidence Act. If we turn to section 91 to 100, the most important part of the jurisprudence is that no oral evidence is admissible if there exists a document. Oral evidence, even to interpret, contradict the written document, is not admissible. Why? It is a simple, because human memory is not sharp, is not that constant. There may be some development, some lapses on the part of a human memory. So in that case, if the document is there, the oral evidence is excluded. But this has an exceptions. And what are they? Number one, if it is shown that the under Indian law, contract can be entered orally. Law allows a contract to be entered orally. Then in that case, oral evidence can be laid as to the contents of the document. I will deal with some case law here so that that point will be clear. The first is 2004 1 SCC, page 12. That is Citibank versus Standard Chartered Bank. This is about a principle which I have highlighted. The best evidence is the original document or the document itself. Now, if the best evidence is not produced, the adverse inference can be drawn. And adverse inference means the party who is not producing is because the document contains or is against his own interest and is not of the nature which that party professes or states before the court. The second case is about when the true character of the document is challenged. And that is Vimal Chand versus Ramakant Jadu, JADOO. It is 2009 5 SCC, page 713. Now here, I will diverge little on the exampling by facts. Suppose the agriculturist residing in a remote area having non-fertile or non-irrigated land takes a loan from the local trader, and local trader gets executed the document styled as agreement of sale, wherein the amount which is paid to such farmer is mentioned. Farmer has admitted the receipt of the amount and the document is in writing. As per the rule which I had outlined, no oral evidence will be allowed. But exception is here. If the farmer wants to bring about the true character, that is, it is a loan document. It was a hand loan. It was not an agreement of sale, not intended to be an agreement of sale. Then in that case, such evidence is permissible to show the true character of the document. Now then, there is another instance in Parvinder Singh versus Renu Gautam, where in 2004, 4 SCC, 794. Now here, let us elaborate on the same example. That farmer's brother has also a land, and along with that farmer, say brother say Ram and Lakshman. So Ram, who is the elder brother, and Lakshman is an uh, the brother who is not elder, who is a younger brother, they both have executed a document of agreement of sale. Ram has also a land equivalent to that of Lakshman, and both have entered into agreement. What happens? The Ram gets the major amount towards consideration because he has brought about this transaction of taking money, and Lakshman doesn't get his share or proper price for the land. It was a very less valued because Ram had already joined the purchaser. Then, in order to show that this document is of a collusive nature, there is a collusion between Ram and the purchaser. This evidence can be brought, oral evidence can be brought or laid by Lakshman before the court. So this is an exception to the phrase which I have mentioned here and above. Now, there is a forgery or a fraud, which is maybe one of the circumstances where the document is sought to be challenged. The burden is on the person or a party who alleges that it is a forgery, it is a fraud. And for that purpose, one can safely rely on Anil Rishi versus Guru Baksha Singh, 2006, 5 SCC 558. The other requirements are there. If there is a fraud, you have to give the details. You have to plead it in detail. How, where, when the fraud took place. Because the fraud which is defined under section 17 of the Contract Act also has various parameters, that there must be a representation which the party making representation was false, or he has projected the land or particular property of such a nature which in fact was never of such a nature. Then in that case, all this becomes relevant and important for consideration. Now, I will slightly diverge on two cases and then I will stop for the question answers. First is that when a copy of a document, say sell deed, is produced and it is exhibited, whether subsequently the adversary can approach the court and say that it is not properly stamped and it needs to be de-exhibited. Here the law which is settled, I will quote the Maharashtrian law, Baban Bangar versus Namdev Bangar, 1998, 3 Maharashtra Journal, page 743. This cannot be agitated in appeal, subsequent stages. Once the document is admitted and exhibited, this fact or this point, even though that is a point of law, cannot be agitated subsequently in appeal. And lastly, it is well-known concept or a principle under the law that court will not look into evidence where there is no pleading. So proof without pleading, the courts are normally not inclined to go into. And that we can safely rely on 2009, 6 Maharashtra Journal, page 948. Ganpati Nikam versus Ramchandra Sawant. Then another case, 2011, 5 SCR, page 587, H. Siddiqui versus a Ramalingam. So evidence without pleading is normally discarded. The court does not rely on such evidence. So this is the stage I will entertain now the questions.
Yes, sir. Definitely, sir. Thank you so much for your valuable